Welcome to the bold analysis, ladies and gentlemen. The question that has been the talk of town is simple. Can Supreme Court declare presidential election winner after a recount or a retally if there is an arithmetic error? That's a question. And one of the constitutional articles that has been mostly mentioned, rather quoted, is the Election Act of 2011. Powers of election court mandate Supreme Court to declare a winner should it call for a recount. Section 80 of the Election Act of 2011 states that an election count may by order direct the Commission to issue a certificate of election to a president, a member of parliament, or a member of county assembly if upon recount of ballots cast the winner is apparent and that winner is found not to have committed an election offense. So, by the way, this Act of 2011, it's not talking about the senator and the governor and the women member of parliament, the county member of parliament, that is the women rep. Does it mean, is it selective that it can apply to the member of parliament, it can apply to the president and member of county assembly, but it does not apply to the governor, senator, and the women rep? Someone can help us get an understanding over that. Now, in the light of that discussion, and I analyzed in my previous video, that the discussion on the probability of Supreme Court declaring a winner, if that winner is not what Chebukati announced, was very conducive and was a very good fodder for Azimio la Umoja against the UDA wing. Because Azimio la Umoja had actually lost the tempo. They had been deflated in terms of what they're actually trying to do. So what has happened is that there has been this question, and the Raila Odinga's wing have been demanding that if a recount is done, then the legitimate winner of August 9th general election should be announced. And according to them, that should be Raila Odinga. So that has been the position of Azimio la Umoja. Well, Kenyan Kwanza online bloggers, I've seen Abdullahi Nasir. I have also seen Miguna, Gladys Boss Sholei, the former registrar of judiciary, actually trying to say, actually coming out to defend or rather to oppose that law that says that the Supreme Court can actually declare the president the legitimate winner of the result. And Miguna alluded to, and that is also what the Grand Mullah was saying, that if there will be anomalies in the results, then someone should only ask for a rerun, or rather someone should only order a rerun. And it should not be that the counting has been done, candidate X seems to have won, and so that candidate is supposed to be given the win. They have stood their ground that that is not the way it should go. So why is it becoming difficult, or why do you think that they are not defending the official position of we have won the elections? And because when Azimio la Umoja submits a case in Supreme Court, then what that means is that President-elect Tag sublimes until that petition is actually until a verdict comes from that petition. So one thing you can see is what I would expect is that the social media lawyers, the lawyers that are prosecuting this case in the social spaces, should be standing their ground that we are not going to take anything less. Let's do a recount and let's make sure that William Ruto is the winner. Even though they defend, in their defense, they must defend William Ruto as the winner. But it seems they're changing that position, and tactically, they want to move away from that and say, okay, if it can come to the worst, then let us go for a rerun. What do you think is bringing this? What do you think is bringing that? Because I want to tell you why Ruto's lawyers seems to be dropping that position of Ruto won the election, but then pursuing another interesting angle of if there is a recount and there is anomalies or there is some discrepancies between the two, the results and what has been counted, then the country needs to go for a fresh election. So what do you think is bringing that? It will be a very interesting piece. Guys, kindly subscribe. We are on 10 days. We extended Sarah's fundraiser by 2 weeks up to 5th of September. Sarah Tieno is one of our subscribers, and she's in Kenyatta Hospital suffering acute leukemia. She had a bill that had inflated to 1 million. We did the first 21 days challenge, and we're in a position to, with the support, with the other approval from the insurance, we were in a position to cover 829,000 Kenyan shillings with a balance of 215. So we did an extension of 2 more weeks so that we can help fundraise Ifike Hiyo, so that on 5th she can be released. So I still continue to reach out to you. You can donate directly. My idea about collecting through my number, because I wanted to know how much Team Bold had collected, and out of the 869 we had collected, out of the 829 that was paid, the Team Board had collected 621. So I believe that's not small. That's good money, really. So I believe that we can achieve this together. I really want to track so that we also take and say this is what we have actually donated. You can do that through my number 0710 62 78 89. Also, you can reach out to Sarah directly, even above the 50 shillings challenge. You can get touch, reach out to Sarah. Her number is 07 16 357 360, and God will bless you. Now, this will be very interesting case in the Supreme Court, and I think the UDA, because one of the interested parties here is IBC and also I think William Ruto or UDA, but I think it's William Ruto, the president-elect himself. IBC has picked Githu Muigai. I don't know how they got their way through that. But then, if UDA, if William Ruto is going to be one of the parties that is going to be represented in court, then because IBC is defending itself, and William Ruto lawyers might find themselves in a very awkward position in defense of the commission. Because for you to defend William Ruto's results that were announced by Chebukati, the custodian of those results, you must prove to the judges beyond any reasonable doubt that IBC was independent. And of course, that is something that's only the commission that are supposed to talk about. You have to prove that you never meddled with anything in the commission. Actually, this will be an outsider telling court the way things were clean at the commission, if you are to defend. So that to me would indicate, would actually inform that direction of, let's not go that way of defending Chebukati. And again, I think at the center of this case, if there is something that Wafula Chebukati and Deputy President William Ruto will not want to happen, is a situation where there is a lot of where the case is profiling the chairman of the commission. If the case will be around Wafula Chebukati and profiling the conduct of Wafula Chebukati, then even before the final verdict is out, it will polarize the ground. This is not something that someone would actually want to envision now. The results of the tally can expose Raila Odinga's majority votes. I wanted to imagine it this way, that perhaps we do a recount. I don't think you can start from a retally. You must start from a recount. Retally is something as easy as just commission sitting there and now doing those figures. It's as easy as just returning the Form 34As or the Form 34Bs. That is something that even the Supreme Court can do. The judges can order their staff to do. So, one thing you can see is, if you go back to a recount and it shows that yes, Raila has a majority win, that would arouse the public emotions. And even if you count the votes, then you realize, okay, Raila alikuwa mbele, then you rouse the emotions, and you never know from that announcement that, okay, fine, Raila has got more votes than William Ruto, so we're going for a rerun. Who knows? The public will turn against that ruling and will demand that Raila Odinga is announced the president-elect. These are all dynamics that are coming into this case, and that is why it is not very direct. Now, there was also the election. If rigging was done, and I want to be very specific, objective on this, if the rigging was done, then it was done above board. Take that to banking board alone. The rigging might have been done above board. So it is something that even if the lawyers are supposed to go and defend, the evidence will not be something that will be very tangible to be presented between a Supreme Court, before a Supreme Court judge. Because honestly, if it was to be done, if it was in the digital space, then that is above board. That is not something that William Ruto side will have strong defense to defend themselves about vis-a-vis the IBC. But also, they will use that open verdict. They will take a different position to what Azimio wants. While Azimio lawyers might stick to the fact that let's do a recount, and if Raila wins, we give the president-elect the certificate. The William Ruto team will then say that, look here, we don't want, instead of going for that recount, let's just go for a rerun. So when these two options are on table, it means that the judges might find a compromise position that simple English says common ground, so that you're not seen as leading towards side A or maybe trying to hit side B. These are all options to leave the judges with wondering. You know, if I'm saying let's go for it, and you're saying let's go for recount, then I'm saying let's not go for recount. Then you're like, what do you want? There's a let's go for rerun. So it means there is a rerun, there is someone who wants a rerun, there is someone who wants a recount. So whichever side, judges might feel like, okay, we are not offering both, we might find a compromise position. I don't know what that compromise position can be. But then, guys, I don't know what's your stake. What are your thoughts? Why, now that it's crystal clear that Supreme Court can actually award the certificate to the winner if it is proved beyond any reasonable doubt that there were arithmetic errors, how do you think this will change the framing of the case on both sides, both on Azimio la Umoja and Kenya Kwanza?